As a contribution to the challenge we face around the need to protect and secure the wages and conditions of those employed in areas governed by the JLC and the ERO system, I welcome very much the publication of this bill and the opportunity to speak on its provisions here this evening. Elements of the bill attract my support and certainly attract the support of the Labour Party and the government in general. The basic principles are, to my mind, philosophically sound. It represents a reasonable effort to address some of the fallout from the Feeney judgment less than 2 weeks ago. However, even to the untrained eye, the frailties inherent in the legislation are all too apparent. Whatever way we slice and dice it, this bill is essentially a reheated version of the 2009 Industrial Relations Amendment Bill, but that was then and this is now. In light of the Feeney judgment, we've entered an entirely different and new dimension. The JLC ERO system, which has served our economy and our society well since its inception, has been struck down as unconstitutional, as we're all too well aware. And despite what some members of the opposition would have us believe, the direct implications of the judgment are such that no quick fix solution exists, as my colleague Deputy Keaveney has said. No quick fix solution that can be simply taken off a shelf, dusted down and represented as something that it's in fact not. We need fresh thinking here to deal with a fundamentally altered scenario, whilst I think achieving the same outcomes enjoyed by those who are employed under the JLC and ERO system. But it would, I think, Lascan Corla, be disingenuous and dangerously misleading for anyone in the House to suggest that this, or indeed any other legislative proposition that has been put forward, whether in this House or outside it in recent days, is sufficiently robust to achieve the outcome I think it's fair to say that there's a degree of unanimity around in this House. Now, I accept that this bill before us tonight represents a genuine effort to have one substantial element of the Feeney judgment settled, and that is the issue to do with the glaring absence of strong guidance in terms of principles and policies from this law-making body in terms of wage-setting mechanisms. And I think this is all well and good to a point, but there's an important point I want to make, and that's I think any reasonable analysis of this particular effort presented to us by Fianna Fáil is completely silent on the entire issue of property rights. Not just in this instance, but in a whole raft of trade union and employment rights legislation, this constitutional issue of property rights has reared its unwelcome head. It's grotesque. I think it's frankly disturbing to me that in the context of this and the context of other related matters, the issue of the protection of the individual property rights appears to have primacy in our Constitution over the rights of the individual citizen to a decent living wage and moreover the right to have those circumstances protected. This whole concept is a matter that should be pursued and examined shortly, I think, by the Constitutional Convention. I noted last night that Deputies O'D across the chamber and Deputy Collins from the party that brought you such hits as the slashing of the national minimum wage and the blanket bank guarantee were straining at the leash to have a go at the Labour Party, asking us what we stand for. Well, Lascan Corla, it could be argued that the crocodile tears they shed on this serious matter are an insult to honest crocodiles everywhere. As my colleague Deputy Alex White said yesterday evening in the chamber, we stand for legislation that will work, and not for legislation that is clearly frail and frankly a bit on the anaemic side. We don't do and we won't do a grand old Duke of York on this and pretend that if this so-called emergency legislation is passed that everything will be okay in the morning. Frankly, it won't. Notwithstanding all of that, the bill requires additional examination that has a degree of merit, as I think we're all agreed upon, and I support what the Minister and the Government is doing now and what we will be doing collectively over the summer period to comprehensively address the issues facing the 200,000 or so workers who need and require our protection and need and require a new and robust structure to robustly and vigorously protect and vindicate their interests and their rights.